Can you hear me now? Good. This is not a Verizon commercial, by the way. If anybody remembers those. Can you hear me now? All right, great. So we're back. So, wills. So when we're talking about will, well, yeah, the guy moved to Sprint, Sandra. No. But he started with Verizon doing it. When we talk about wills, we're talking about last will and testament. Last will and testament. This is when we're telling... Sorry, I'm having issues with my, for some reason, the YouTube. Okay. That's what it is. If you're watching on YouTube, let me know you're still there, because right now, my server says that it's down. I just want to make sure. Okay, still there. Okay, great. Cool. All right, guys, just give me 1 second. I'm trying to get into... There you go. All right, so Sanam says she's there. We're good. Flowing. Great. So we're talking about last will and testament. What does that mean? It means that pretty much if I die tonight, right? If I die tonight, here's how I want to distribute my assets. That's all it is. Whatever I own, if I die tonight. So a lot of people steer away. Make sure your cameras are on, people. A lot of people steer away from preparing a will because they're like, hey, I'm going to live forever. I'll never die, right? So a will is not because you will die in the future. A will is just in case, you know, whatever date you set for yourself, like I'm going to live until I'm 100, just in case that date comes sooner, right? It comes like at 30 or 40 or 50, right? You're ready for it. We never know when the time is coming, right? My mom, for instance, she was 46. I thought she was going to live forever. I hoped she lived forever, and she, same. But unfortunately, 46. That's early in her age. I'm only 7 years away from her age when she died. So we never know. This is the thing about wills that you guys need to understand. A will is just in case something happens now. Here's how I want the assets to be distributed. That's all the will is for. Versus the government determining how it should be distributed. Okay? So there's different types of wills. One of the things you need to know about a will is that it transfers the property after the owner's death. Okay? And that's transfer of real and personal property. In fact, before we move forward, what's the difference between real property and personal property? Please tell me in the chat, what's the difference between real property and personal property? All right, there you go. Whether they're movable or not. The difference is whether they're movable or not. That's the first thing to identify real or personal. The second thing is, and you guys wrote it here perfect, real property is attached to the land or improvements. Perfect. Because they're fixed, they're immovable. That's the biggest difference between real and personal property. So a will can transfer either or it can transfer both. It's whatever we decide. Okay? Now, if you have a beneficiary of a will, it's called an heir or devisee, while the person creating the will is a testator or devisor. The transfer of property by will is called a devise. When we transfer property by will, it's called a devise. Now I'm going to write another word real quick. Transfer property by will is a devise. If transfer property by will is a devise and it means somebody died, what is a demise? D-E-M-I-S-E. D-E-M-I-S-E. What is a demise? Remember the word, but not the meaning. Okay. So there's devise and there's demise. What's the difference? Joanna says passed away. Okay. But we just said that transfer by will is a devise. So what's a demise? What's the difference between devise and demise? With a V or with an M? All right. Nice wrote the end. Okay. Have here. What else? Involuntary, leave, downfall, death. Not by will, just dies and gets passed down. Transfer of death. Okay. So, a demise, guys. Demise is a transfer by lease. Demise is a transfer by lease. Okay, I'm sending the chapter for those that just asked for it. I'm sending the chapter right now. Okay, go ahead. You were saying? So devise is when you have a will prepared, you're transferring property. So it's when you die, transfer property by will, right? Where a demise is when we reach the end of something, it transfers to something else. So when we say the event of my demise is because the body that we have right now, guys, the body we have right now is a rental. It's a rental. So eventually, our body ceases to host our soul and we're gone, right? That's the theory of demise or transfer by lease. So rent is up. We're done. Rent is up, right? So for those that believe in the afterlife, right? That's what it is. Your body dies, but you continue by transferring to something else. So your body becomes something else, and you continue to be something else. Lease is up. Transfer. So here's what you need to remember. Devise is transfer by will. Demise is transfer by lease. Devise is transfer by will. Demise is transfer by lease. All right? Actual will or your own will? I mean, so the demise is transfer by lease. Devise is because you created a will. So you created it. You have one. You prepared one. Okay? Okay? So, all right, so Nam is asking, I think when you get the property as a gift, it's called a devise. So, no, the devise is right here. Look. The devise is the transfer itself, how it was transferred is a devise. Okay? A gift or legacy or bequeath is the fact that something was left to you, right? So in a devise, when something is left for you, right, that something is called a legacy, a bequeath, or a gift. Okay, so it's the inheritance. That's what the gift is. Okay. Not here, not in this chapter. I'm just putting it here because later on we're going to mention it. That's why. Don't forget, I keep on trying to connect the dots. So I'm mentioning demise now because you're going to see that similar word later on, and I want to make sure that you understand the difference. Okay, again, this is my strategy. It's been working for a while. Hopefully it keeps on working. But I'm always up for improvement if there are suggestions. But I try to tie in things as we go. So always come back, always move forward to tie in the stories. Now, if there's a testator, that means there's a testament. There's a testament, there's a will. That's the last will and testament. Okay? So with a testator or the creator of the will name an executor. So a will exists. Okay? So for an executor to exist, that means there's a will. When I prepare a will and I say, Carly, you are the executor of my will. That means, Carly, when I die, you will hold the will and you call everybody that I name in the will. And you're the one, Carly, that's going to say, hey, for this person, this is what you get. For that person, this is what you get. For the other person, this is what they get. So you're the one reading and executing what was my will. Okay? So that's an executor. If there's no will, then we're going to have a court administrator, as I'll talk about later. So if there's a will, there's an executor. Now, for a will to exist, okay, there has to be either witnesses. It could be holographic, that means handwriting. Okay? Or in an approved pre-printed form. So this depends on the state. In the state of New Jersey, we now allow holographic wills. We allow witness wills, but we do not require pre-printed forms. We do not require a pre-printed form to be a valid will. So you can literally just write whatever you want, and boom, that's your will. Okay, whatever way you want it. As long as it identifies who's the one that's devising it, so who's the devisor, which is me, right? And who's the one that's the beneficiary or devisee, right? And what the assets were. As long as we identify the people, not a problem. Okay? It's not they do not allow, it's there's no standard form. It's not a required. So some states, for a will to be valid in that state, it must have an approved form. Pre-printed, approved form, fill in the blanks type of thing. For instance, yeah. Okay. Yep. So to die with a will is testate. Yes. So if you die testate, you have a will. If you die intestate, you have no will. Okay? So are you saying in New Jersey you can handwrite a will and it's valid? Yes, that's what I'm saying. As long as it's handwritten, dated, and signed, it is valid. No, it does not have to be notarized or witnessed. But look, just because this is authorized now in New Jersey as an example, holographic wills, because it's authorized, right, doesn't mean this is the way you should do it. So the holographic will, think about it, you're on your dying bed, right, and you say, you know what, I want to change my whole will, right? Grab a piece of paper, grab a pen, as long as you're on of sound mind while you're doing it, you're handwriting it, that's it. That's your final will, okay? Last will and testament. So it is valid. Does it have to be? I just mentioned. No. What? Oh, non-cubital. No, I'm not there yet. What about typed out? Yeah, as long as it has witnesses, as an example. Say it again. Doesn't have to have witnesses, no. If it's in typed, yes. The requirement will be two witnesses. Yeah. So if New Jersey just approved being holographic, what was it before? It had to be typed. Yeah, it doesn't make any sense. What it is kind of like at one point they stopped allowing the holographic wills because, or handwritten wills because they're of potential fraud. I guess now because it's easier to identify or the type of handwriting if it did belong to this person or not. I guess that might be the reason why they allow it again. Okay, the other question is, if someone wants to pass down the house, how many years or months prior does it need to be added to the... It could be my last will and testament tonight. I don't have to I don't have to have certain amount of months or years to include something in the will. In fact, a will, guys, a will is it's a living, breathing thing. It's a living and breathing thing, meaning while you're alive, you can amend that will as you go. You can adjust it as you go. Right? Whatever you establish today, right? So my will 10 years ago has nothing to do with my will now. Because I've sold properties, I bought properties. Okay? That's it. 10 years ago, I had another heir to my assets, but that heir is no longer around, unfortunately. So I had to remove a person. Then meanwhile, I have two more kids, so those were added along the way. You know what I'm saying? So it keeps on changing. Your life changes, so should your will. Okay. So there's no exact amount of time to be added or removed. It just has to be there. Okay. If it's the last thing, I just bought it yesterday, and today I decide to put on the will. Boom. So when you write out the will or type the will, where do you file it? Like, how would someone know you have it? So this is why we appoint. This is why we appoint executors when we prepare a will. It's not where it's filed, even though you should file it in public records. I'll explain that in a second. But you appointed somebody, right? So if I give you my will and say, hey, it's sealed, here's my will, I named you as the executor, only open this if I die. Okay? So when I die, you open this and execute my will. Simple. So somebody has it. That person will claim it, right? What I always recommend is that you put it into public records. Go to your municipality, for instance, and you ask them to file under miscellaneous, so it's a written record, meaning it cannot be altered or disputed. That's the key. Because especially if you have siblings, sometimes it sucks. But money changes people, especially family. Money changes. Oh, how come he gets this and she gets that and I only get this, right? So there could be disputes between the family. To avoid that, to avoid them thinking there was some type of coercion, right, or influence, to avoid that, put it into public records when you prepare it. This way, no, this was filed as well. There was no alterations of the original will, right? Or if there's alterations, always amended by the same person, not by one of the heirs, right? And I tell you this because a couple of years ago, I had somebody come to my office to prepare a will. I had a multi-service company at one point, so they came to my office to prepare a will, and it was the 96-year-old mother with the 50-something-year-old son. Okay? So he's there, and I'm asking questions to the mother, and he's the one always butting in and saying, no, but it has to be this way. It has to be that way. And he has a sibling. And I kept on saying, well, looking at the mother, what about this other son that you have? What about this? What about that? And he kept on answering. I'm asking the mother, the person preparing the will, but he kept on answering. To the point I told him, please leave. Let me speak to your mother because she's the one preparing the will, not you. Right? I said it in nicer words, but he still got offended. They both left. And then I think about 3 or 4 months later, here comes the mother, slowly getting to the door, slowly. I see her. I open the door. Hey, how are you? And she came to do the will by herself. All right? So this is what I'm telling you about preparing wills and putting into public records and having the right people and witnesses so it's not disputed. The other brother could have disputed the whole thing, right? So again, things to think about. Okay? What page? This was page 79, but we're on page 80 right now. Okay. All right, so the next page, it says state law establishes the requirements, okay, establishes the requirements for a valid will. So every state determines what it's needed or not, right? But general requirements are right here. The general requirements is that the testator, so the one preparing the will, think about every time you see OR, think about creator, right? The creator of it, right? Or the owner. OR would be short for owner as an example. So creator or owner. Guys, make sure you're paying attention. Whoever's in the room with you, and you know who you are, whoever's in the room with you, kick them out. All right? If it's your kids, put them in the closet. All right? If it's an animal, put it in the closet with the kids. Right? Make sure there's enough room. All right, Denise? You know who you are? You know better, Denise. Really? I pick on you. Don't yell at me. I'm just saying. I cannot hear you, but I know you're yelling there. This is the beauty of being behind the screen and muting them.
Okay.
Yep.
I can.
All right. He just says just me and Gasper. There you go. I skipped. Well, the non-competitive is not really that important.
Okay.
But all it says is that let's say you're a nurse, I'm at the hospital, I cannot write it, so I'm speaking to you what you should write on the will. That's all it is. Okay? So for transfer property, it's generally not valid as it says. So that's why I also skipped it. All right, so again, so to make a will valid, depending on the state that you're in, you have to be of legal age and mentally competent. You have to indicate that it's your last will and testament, that it will be signed, and that it will be witnessed and signed. Okay? Witnessed and signed by the witnesses. The will is completely voluntarily, without duress or coercion. Okay? All right. All right. And anybody could be a witness. What I usually recommend, just because of the scenario that I mentioned earlier, never have a witness that's a family member, like direct family member that will benefit from it. So pretty much if it's a beneficiary or direct to the beneficiary, do not have him be a witness. So for instance, if I leave something to my kids, right, I don't want the witness to be the spouse of one of them, right? Because then again, there's an interest there. So always try to get a third party unrelated to the beneficiaries, right? That's at least my recommendation as far as witnesses. The witness could be the attorney, be the secretary of the attorney, Be your friend, whatever. All right. Now what? Not a dog. No, that's the beneficiary only. Probate. This is court. Okay. So we go to court when somebody dies. Now it's not court like, hey, I'm going to sue you. No, but probate court exists to define who is entitled to what. Probate court exists to define who is entitled to what. Okay? So, and in saying this, and we're going to go over this in a second, in saying this is, when I die, I have debts to be paid. So, do my kids get all the inheritance? No. The first thing, and that's what probate is for, is to figure out who's entitled to claim the inheritance after the debts have been paid. Okay? So if I have $1 million that I'll leave behind, then do I have debts? If I have $900,000 worth of debts, then how much is really left? It's $100,000. It's not $1 million. Okay, so those that gotta be paid first. So a court proceeding called probate generally settles the decedent's estate, whether the person died testate, that means left a will, or intestate, without a will. Okay? Testate, you have a will. That means you have a last will and testament. It's the state decides because you did not prepare one. Yep. So the court's objectives is to validate the will if one exists, to identify and settle all the claims or outstanding debts, and to distribute the remainder of the estate to their rightful heirs. If the will does not name an executor, then the court will appoint an administrator. So, if you're named in the will, right, Carly, I said you were my executor, that means I prepared a will. If I said that there's no will or no executor, then the court will say, well, Katya, I appoint you as the administrator of the estate. So there's executor of the estate and there's administrator of the estate. Executor, named by the person that created the will. So named in the will. Administrator is named by the court or appointed by the court. So if you see a question there that talks about administrator, look for the answer that has court in it, okay, or judge. If you look at a question that says John was appointed in the will, look for the answer that says executor. So if there's a will, it's executor. If there's no will, it's administrator, because it's the court that appoints. Okay. All right, so here's the example real quick. Transfer of a decedent's estate by probate. All of these go through probate. Whether you have heirs, right, and you have a will, you have heirs but you have no will, or you don't have a will or heirs. Okay? So if you have heirs, the process is the first people to receive the right to a claim are the creditors. The second people to receive right to the claim are the ones with the legal life estate. Guys, who remembers legal life estate? Anybody? Legal life estate. Married. Perfect. So if you're married, your spouse will receive the property through either dower and courtesy, homestead, right? Or what was the third one? Anybody? It was dower and courtesy, homestead, elective share. Carly, perfect. Elective share. Okay? So that's a legal life estate. After we figure out if there's a spouse or not, then the heirs will receive it based on whatever the will says. Okay? And if you guys don't remember the elective share, this is where the spouse can say, what do you mean you left everything to the kids and not to me? The elective share is where the spouse can say, well, I'm entitled to, like in New Jersey, 1/3 of the estate, minimum amount. Okay? Guys, there's a lot of you without cameras. Make sure your cameras are on. Otherwise, it does not count. All right, so the next one is you died without a will, but you have heirs. Okay, the process, if you don't have a will, the process is the same. First, creditors. Second, legal life estate. And third, heirs by descent. Okay? Wafa's asking who's heirs. So heirs is whoever you appoint in the will. Whoever's rightful appointee of the will. So I can say, Wafa, that you're my heir in the will. Okay? But if I have no will, then there's the laws of descent and distribution. So the government determines, and every state is different, but the government determines who is your immediate heir. So who's rightful heir of your assets. Okay, so heirs is whoever survives us, right? In the will, I can say that my heir, who I appointed, is Columbia University. I can say that my heir, whoever I appoint in the will to receive all my assets, right? Whoever survives me and receives all my assets is, let's say, Uber, or I don't know, whoever I want to appoint. But usually we have what's called natural heirs. Natural heirs are our kids first, or the spouse in this case first, then the kids. If there's no kids, then it goes to grandparents. There's no grandparents, so I'm sorry, the parents. There's no parents, then it goes to others. So Ligia just wrote cousins or heirs by descent. So those are natural heirs. Okay, but if there's no so this is the descent, natural heirs. If there's no natural heirs, just wrote no. If there's no natural heirs, then the government, let's go here. You have no will and no heirs. Then the government pays the creditors first. Then it goes to the state by escheat. Okay, so every time you see this word escheat, that means the state cheated you out of your property. Why? Because you died intestate. What does intestate mean? Again, no will and no heirs claimed. No will and no heirs claimed. Okay? So that means I have no will. My spouse is supposed to be the first one. Then the kids are supposed to get it. If nobody shows up and says, hey, government, I'm the natural heir of Bruno, therefore I'm entitled to this property, right? If your heirs don't show up to say anything, to claim anything, then the government takes it from you. What they'll do is they'll auction the property. So somebody buys a property. Then they keep the money for an X amount of time, depending on the state. Like state of New Jersey, they'll keep the money for 1 year. If nobody shows up to say, hey, where's the property? And they go like, no, there's no property, there's money. If nobody shows up, not even to claim the money, then that money belongs now to the state. Crazy, right? No, in New Jersey is 1 year. Could be different, yes. Okay? This is why it's so important to prepare a will, right? And you determine who to give it to. Because there's another issue. The other issue is that the property is distributed according to state law. So if I have a property in New Jersey and then I have a property in New York and a property in California, they might be distributed in different ways, depending on the state that they're in. It's not my will, it's whatever the government decides. So a will is very, very important because of that. What happens if you have heirs but we do not write the will? This is what happens. Wafa, right here. If you have an heir, I already covered this one. The process is the government will go after creditors to pay them. Will go after the spouse, even though it's not named in the will, to pay the spouse. And then they distribute it to the heirs according to whatever the government laws are. The problem is, again, even though this is the distribution, if people do not step up to say, yes, I am this person that's entitled to it, if there's no heirs that claim it, then the government gets it. So just because you have heirs does not mean that they'll get it. They need to claim it. Okay? All right, we talked about this. Next page, we're on page 82. We have involuntary title transfer. Ruth, how long to claim it? Depends on state laws. Every state has different amount of time to claim inheritance. So you have to figure out what the probate rules are for the state. For state exam, it's not that important, so that's why I'm not even bringing it up. But you need to know that everything is ruled by state law. There's no national law that says this is the amount of time. No. Okay, so it's statutory. It depends on the state statutes. Probate is going to court to figure out who gets what. All right, involuntary transfer. What does that mean? It means you're being forced out of the property. Okay, you're forced out of the title. How does that happen? Well, again, look at the very first one. Look at the very first one under involuntary transfer. Didn't we just talk about this? Laws of descent? This is when you have no will. The government determines what your will should be. So they distribute the title or transfer properties according to their decision, not yours. That's the very first one there. The second one is abandonment. Third one is foreclosure. Fourth one is eminent domain. Fifth is adverse possession. And then estoppel. So guys, we talked about all these already. So it should be like a quick recap of the past 2 days. All right, let's see how much you can remember from the past 2 days as far as these, right? First of all, from earlier today, what is alienation? What is involuntary alienation? In this case, what's alienation? Let me know. Okay. I'm not asking what's alien. Guys, you're answering what's alien. I'm asking the whole word. Alienation. Now, the deed is what transfers what? It's transfer of? What is this chapter about? Carly, perfect. Transfer of title. If it's involuntary alienation, that means it's transfer of title to somebody else without your authorization. Perfect. So alienation is transfer of title. Shanae says they took it. They snatched it from you. That's what it is. So involuntary alienation occurs when the title holder dies without having a valid will, for instance, right? The state statutes of